And again, welcome everyone. Thank you for joining us for our financial planning presentation, part of Kerby Center's ongoing series of online presentations on health and wellness, education, mental well-being, entertainment, and information presentation series. The past 2 years have been particularly difficult for our seniors, and many of you, in addition to maintaining your good health and navigating through isolation, have had real financial concerns. With the current economic climate, retirement investments may not be reaping the returns you hoped for, causing worry about your economic future. We hope that this series of presentations will help provide the information you need in order to make the right decisions to ensure your financial well-being and to put your minds at ease that your wishes will be taken care of when the time comes. We are very pleased today to welcome Jonathan Ng. Jonathan practices at Underwood Gilholme Estate Lawyers, a group that works exclusively in estate matters. He assists clients in the preparation of wills, enduring powers of attorney, personal directives, and trusts. He also advises executors and attorneys on the administration of estates. In addition to his experience in making court applications for grants of probate and administration, he has appeared before the Court of Queen's Bench on applications for the validation of non-compliant wills and family maintenance and support. Over the past several years, Jonathan has provided seminars at Chinook Learning Services, Kerby Center, and the Canadian Association of Gift Planners. He has also appeared on CBC Radio to discuss the importance of having a will and estate topics. Jonathan is a member of the Canadian Bar Association South Alberta Wills and Trusts section and the Estate Planning Council of Calgary. Jonathan, thank you so much. Welcome back, and we appreciate you joining us again today. Why is it important for each of us to have an effective end-of-life plan and our wills and estates in place?
Wow, big question to start the day, Colleen. Thank you. Well, first I just want to again welcome everyone. Thank you for joining, and thank the Kerby Center and Colleen for the warm invitation. You ask a big question: why do we have a will in place? What is the role of a will, and what is this term estate planning that we hear about from time to time? Well, these are all topics we're going to hear about today, and I'm very privileged to be joining for the third time. And when I was putting my slides together, I thought to myself, what has our Kerby audience not heard about yet? Well, there's tons of things. So what I've done was, reflecting on the first presentation and the second presentation, I put together a set of slides sort of focused on what I'm going to call common questions. And here we go. The slides are now up on everyone's screen so that you don't have to stare at my head for the next hour. We're going to look at these slides and we'll be talking about what again, I'm calling common questions. These are questions I hear from clients every day, questions that I've heard from previous Kerby presentations, and certainly issues that we as lawyers face when dealing with our clients every day or from time to time in courtroom dispute. So I hope that this resonates with everyone today, and I'm going to do my very best to try to finish up maybe after about 35, 45 minutes, so there's plenty of time to address questions. I see that the chat function is running, so I think Colleen's in a position to take questions, and we'll do our best to address them at the close of the slides. So here we go. Common questions about estate planning. These are the five items that I wanted to focus on today. Firstly, choosing your executor. Choosing your executor. A lot of things to consider in putting someone in this role. Next, beneficiaries. This is the big part of the will. This is the giving. And there's sort of two sort of ways that you give in a will, through bequests and through residue. More on that later. The third item is something many of us may have heard of called probate. I am probably asked this probably every day. What is probate and how does it affect me? Is it something I should be avoiding? Is it something I should be worried about? So I'm hoping to dispel some myths there. Next, jointly owned assets, a topic that concerns many senior Canadians. So we'll delve into that item. And then finally, as a tip of the cap to Advanced Care Planning Day, which happened just this last Saturday, April 16th, we'll talk about the personal directive and beyond, because the personal directive is not the be all and end all of your advanced care planning. There are a number of other tools and documents that I want to touch on. So 5 items today, and do bring up, if I don't touch on any of the questions that might be on your mind, please add them to the chat or to the Q&A. So our first topic is choosing your executor. So let's cover our bases here. What is an executor? This is the person or institutions you choose to administer your estate. Follow the terms of the will. Make your wishes happen. So some considerations here are the duties. What are we asking the executor to do? Because considering these items will probably inform your choices. I always tell clients that the executor is thrust into this job immediately. They are planning a funeral for next Saturday. Sounds awful, but the executor is put in this role. So they have the discretion to make funeral directions and make funerals, execute on funeral instructions. So they start quickly. They start quickly with final affairs. They move very quickly then into generally a financial role. I use this term, legal title to all your property. Basically, they need to find your stuff and gain control of your stuff. And the will is the tool they use to meet with banks, ultimately to sell real estate, to file your taxes. On taxes and debts, these are a first claim on your estate. So an executor must apply your assets, right, to pay any existing debts, pay for final income taxes, maybe even past income taxes that have not yet been addressed, and pay for the expenses in administering the estate. Comes out of your assets. And that's something I always want to remind our guests today. The executor is not personally liable for your debts. They are responsible for using your money to pay for your debts, and that's something they have to do very carefully. Distribute assets to your beneficiaries. So a properly written will set out gifts, and we'll talk about gifts in a moment, but they are challenged with this role. They're charged with this role of handing out the gifts you set out in your will and distributing the money in your estate. I'm often asked, how big a job is this? What are we talking here? Well, every estate's a little bit different, but I like to tell my clients that when you're choosing your executor, you are assigning somebody a part-time job for the better part of 2 years. The better part of 2 years. Now, they're not going to be doing this every day. And much of the role of being an executor is waiting for tax filings, waiting for court matters, waiting for the lawyer to get some documents together, waiting to meet up with your realtor. But the whole job can certainly span over a year and a half, 2 years, quite easily. It's heavy, I would comment, for the first, I'd say, 4 to 8 months. And then it's a little less heavy, but something to consider. You know, who in your life, right, has the bandwidth who can take this on? That's a consideration. And finally, this kind of opens up a whole can of worms here, but acting as the trustee of any trust. So the executor's job, in a nutshell, is to get your estate into cash, net of taxes, net of debts. I know there's more to it, but that's the heart of what being an executor is all about: getting your estate down to cash. Some wills will say, for example, give 1/3 of my estate to my nephew, Stephen. Now, Stephen in this scenario might be 17 years old, a young person, might not be ready to receive that kind of money. So the will might go on to say, Stephen's 1/3 share shall be held in trust until he's 25 years old. Aha, we have something called a trust in this will, a relationship where someone is holding money for the benefit of another. This is a big job. And based on Stephen's age and the scenario I put to you, this is going to be a 7-year job. So it's not uncommon for a person preparing their will to ask their executor to be the trustee of that money. So be mindful that in that scenario that I put forth, we are asking the executor to do the 2-year job of turning this estate into cash, but we're also asking them to take on the 7-year job of holding money for a trustee. So be mindful as to how long your executor's job really is lasting. So some traits. This is kind of a mixed bag of comments here, but let's talk about traits of a good executor and some of the considerations of choosing an effective executor. Personal traits that I find to be lend themselves well to being a good executor is being organized. right? Someone that's driven, someone that gets things done. A person who might tend to dither with a decision, struggles with being definitive, with making a call, might find the role of executor difficult. Right? The duties of an executor, kind of touching back on the previous slide, they're not rocket science. I want everyone to not be perturbed or worried about the work of executor. I mean, you're moving money around, you're closing bank accounts, paying bills, selling real estate. These are all things that we may have done over the course of our lives. What makes it tricky or a little more complicated as an executor is that you're doing it under a shortened time frame. And furthermore, you're doing it with a peanut gallery of beneficiaries who are expecting you to do your job diligently, quickly, and with very careful attention. So that's really what makes executor work difficult. And being organized and driven, get it done, tends to help tends to really service those needs very well. The diplomat. So I meet a lot of clients with adult children, and let's say, for example, they have 3 adult children, and one of them is an accountant, right? A professional accountant, a CPA, works at a busy accountancy downtown, is a fancy partner. Those clients might say to me, well, we need to choose our daughter. She's a partner at an accountancy firm, and she knows a thing or two about taxes and finance and management. She's the one to choose. And I agree. I think a person's day job should be considered when you're choosing an executor, but let's dig a little bit deeper. Specifically, this term, the diplomat. Is that daughter a trusted person among the beneficiaries of your estate? Does she have the trust of, say, her brother and her sister? Because regardless of her day job, if she doesn't inspire confidence around the people she's surrounded by that are part of this estate, then she might have a complicated job because we lack some of that good chemistry. So the diplomat is what I look for as opposed to necessarily a person's day job. Furthermore, on this example of the daughter who's a busy partner at an accounting firm, she might not have the time. So consider that part-time job for the next 2 years. Is this a person who can carve out time in their lives to dedicate to the administration of your estate, the successful administration of your estate? I'm often asked, can I appoint my 3 children to be executors? Absolutely, you can say, I choose my 3 children to be what's commonly known as joint executors or co-executors. Careful. Now, there's a reason why there's normally one president of a company and not co-presidents. Sometimes we're putting too many cooks in the kitchen here. I touched on all the duties of the executor and the time constraints and the expectations. On one hand, it helps to choose a panel of people. I get it. Having a team certainly can move this ball forward, move this estate administration forward faster. But having one person in the decision-making role of executor does make things easier. In my experience, move things faster. When you choose multiple people to act as an executor, they have to work together. They have to make decisions unanimously. They have to show up at meetings, say, for example, with the lawyer or the estate accountant or the realtor or the banker. So we're navigating around people's personal lives and trying to make sure that they're available logistically, and they also have good chemistry. So do consider when you appoint an executor, choosing 2 people or more can get complicated. Many people will say, you know what, I'm not comfortable choosing my adult children. I'm not comfortable with my extended family. My brother's my age. He's going to pass before me, or my sister lives in Nova Scotia and she's 82. I'm kind of stuck here. I don't know who to choose. So do consider third parties. Do consider third parties. For example, close friends or acquaintances are possible choices as executor. Right? Do run it by them. They don't want to find out at your funeral. So do check with friends if they're willing to do this. If you're without friends or family members that you're comfortable appointing, there's a whole world of third-party executors, commonly referred to as a corporate executor or a trust company. So essentially, you're appointing the bank to do this job. And a lot of pros and cons about asking a trust company to be an executor, but the main one is convenience. You're choosing someone or an institution that has been doing this for maybe 100 years. They've administered thousands upon thousands of estates. They're not finding time in their personal lives to do this on their evenings and weekends. They do this every day. Trust professionals that do this every day. They are without the emotional and personal baggage that might come with being an executor. They'll do this professionally and in a neutral way, especially if the beneficiaries of your estate might have some chemistry among them. I'll put it that way. I guess the downside, and I really don't want to portray this negatively, is the cost. This is not a free service, and I do encourage everyone to consult with their respective banks and associated trust companies to get their fees. But at a high level, I would estimate about 4% of the gross value of your estate would be dedicated to these fees. 4%. That seems like a lot of money. $40,000 on every $1 million. That's a lot of money to do this job. Now, watch out, everyone. An executor is already entitled to compensation. So whether you choose a trust company, your brother-in-law, or your adult daughter, they're entitled to be paid. And that entitlement sits in the range of 1 or 2 up to 5% of the gross value of your estate anyway. So from a business standpoint, you can appreciate that a trust company is going to value their service on the higher level. And why not? They see themselves as the Cadillac service, and I would agree in most cases. They certainly are going to do it professionally, and they're going to be paid on the higher end of the scale that your brother could possibly collect anyway. So maybe it might be a prudent decision to say, you know what, pay my brother who's going to cobble his way through it, or pay the trust company, a bank that'll do it professionally. Maybe that's the way to go for you. I often hear this advice, especially with some of my senior clients. I have to choose someone that's younger than me. Sure, I get it. For all the logistical and practical reasons, choose a younger executor. But it's not uncommon that I meet retirees who are choosing a brother or sister-in-law who is a contemporary, who might be in their mid-60s, or people that are perhaps my age. I'm 41 years old, and it's not uncommon for someone in my position to choose their mother to be their executor, right? On the idea that maybe mom is in her 60s, maybe early 70s, recently retired, retired professional in her own right. She has the time, right? So this advice that it has to be someone younger than you, I think is good advice, but not gospel. And I do recognize that, sure, things can change very quickly, whether you're appointing an executive who's 40 or an executive who's 75. Healthcare health condition and their availability change quickly. So do appoint an alternate executor. So for example, in your will, it might read, I choose my spouse. Failing my spouse, it shall be my sister. But failing my sister, it shall then be my niece or one of my adult children, right? So we have a sequence of people to take this job if someone cannot do it. I'm often asked, can I choose someone that's out of the country or out of town or out of the province? Absolutely. Absolutely. I'm not particularly fussed about someone who's out of town or out of province or even out of country. For that reason alone, what I am concerned with is the logistics, right? Is it possible for those of you joining in Calgary, is it possible for you to sell a property that exists in Corner Brook, Newfoundland? Absolutely, right? You can make your way out there, make some connections with real estate agents, maybe an auction service that'll clear out the house, and you can come back to Calgary, and thanks to the magic of remote signing and courier, you can get things done. You can sell that property remotely, but it certainly is easier if you lived in Corner Brook, Newfoundland. And that wisdom applies here. There's a lot of running around to do. And although possible to be out of town and do this, it certainly is easier if you're in town or in province or in country for that matter. So again, consider what those logistics look like. And again, this touches back to that person's personal life. If maybe you are appointing someone that lives in Saskatchewan to administer your estate. Yes, that's an out of province matter, but maybe this person is retired. Maybe this person comes to Calgary personally, on a regular basis anyway. So it's really not that much of a concern. So do consider that, it's not an awful thing to choose someone that's out of town, but think it through. And finally, this goes without saying, get their approval. Run it by your executor. When you're drafting your will or updating your will, run it by your proposed executor. See what they think, see how they feel about it. And if it's not a confident feeling, then maybe you need to look on. The giving in a will, the beneficiaries, the people we choose to receive. There's two categories of beneficiaries that I want to put forward here on the through the slides here in this presentation. Bequests and residue. So a quick definition here on the slide: a bequest is a gift given through a will. It can be a very specific item. So for example, to my nephew Isaac, my entire Coca-Cola bottle collection. So we've identified a person and we've identified a specific thing for him or her to receive. It can come in the form of a cash gift. For example, $1,000 to each of my grandchildren. Again, we've identified a fixed amount of money and a fixed class of people, grandchildren. Sometimes we'll name them, especially if there are step-grandchildren, something to consider for those of you out there who have blended families. And then certainly gifts can be to friends or charities. $1,000 to Kerby Assembly. We've identified the charity name. We've identified the amount of money. This is a fixed gift, so to speak, right? We've narrowed the bounds. Who's receiving and what they receive. So what is residue then? Oh, pardon me. I've lost the slide here, but I'll define residue real quickly. The residue is what's left in your estate after taxes and debts and expenses and bequests have been paid, right? So what does this tell us? This tells us that the beneficiaries of the residue are paid last. And the way this normally looks like in your will is I divide my estate equally among my 3 children. What that person is saying is after the dust is settled, after real estate has been sold, after cash gifts and bequests have been handed out, split what's left among my 3 children. And in most situations, this is the bulk of the estate. These are the large shares. So let me bring this into focus. Someone might write a will that says, here are some 3 important charities in my life, and here are 3 important friends in my life that have been a real big part of part of me and part of maybe my final years, so to speak. And they each receive $1,000, right? I love these 3 charities and I love these 3 people, but I just want to keep it simple. They get $1,000 and then split the rest among my 3 children. That individual is in the background is likely saying, I love these 6 groups, these 3 charities and these 3 people, but I like them to the tune of $1,000. They're probably also indirectly saying, my kids are my main focus, and I want the bulk of my estate to go to my 3 children. That's the context of what's normally happening here. Now, my first point on this slide in front of you is saying, be mindful of the value of the bequest because it affects the value of the residue. So if this person we're talking about, this fictional person, has an estate that's worth $100,000, then they're essentially saying, take $6,000 off the top and then split the remaining $94,000 among my 3 children. That makes sense, right? They're giving the bulk of their estate to their 3 kids. But let's change the facts. What if this person has a very modest estate? What if they have an estate that's worth $10,000 at the time of their passing? So $6,000 off the top, and then their 3 kids splitting $4,000. I would think that might not be a properly crafted will at that time. Because if that person's objective was to give the bulk of their estate to their children, they've inadvertently, through this will, very generous will, has actually given their kids less than what's going out in bequest. So always check if you have bequests set out in your will, which you don't have to. If you do have these cash gifts, always do some back of the envelope math and make sure, hey, what's going out to these charities and to these friends and to these extended family members, and what's going to residue. The beneficiaries of the residue, I use a term, they have a seat at the table in the estate administration. What does that mean? Well, let's look at the bequest first. If you have 3 people in your life that are receiving $1,000, the executor of your estate, so after your passing, the executor of your estate is accountable to those 3 people and is accountable or responsible and required to get that $1,000 to those 3 people, okay? So a few points on that. The beneficiary who receives $1,000, they're in the right to call up that executor and say, hey, I know we lost our friend Bernice 6 months ago, but I wanted to check in on how that $1,000 is going. That executor's got to answer that question. That's a fair question. Let's say that beneficiary calls the executor 3 years later. Hey, I haven't heard from you in a long time. It's been 3 years since we lost Bernice. How's that $1,000 going? By the way, that's pretty long estate administration to not hand out gifts. That executor is in the hot seat there, but do be mindful. That executor is accountable to that individual for the $1,000. And they need to get that done. Let's jump into residue. Staying on this fictitious will, where the will now divides the residue among 3 adult children. Those 3 adult children have, again, a seat at the table, a sort of an amplified voice in the estate administration. They can ask the executor a whole bunch of things. They can say, number 1, where's my 1/3 of the estate? They can also say, I want to see a copy of the will. They're entitled to see a copy of the will as opposed to the $1,000 beneficiary. They are not entitled to a copy of the will. Furthermore, this beneficiary of residue can say, I want to see a listing of all the assets in the estate. I want to see what's referred to as an estate accounting. Show me a balance sheet. You've been administering this estate for 3 years. I haven't seen a dime. I want you to account to me all the activity that you've been doing. All of these questions by that beneficiary are very fair, especially after 3 years, which would be uncommon, by the way, everybody. But say even after 8 months, that question is a very fair question. So you can appreciate how being a beneficiary of residue puts you at the table. Now, do be mindful, you're not in control. That beneficiary is not in control. It remains the executor, but that executor is accountable to that beneficiary. And that makes sense, right? If that beneficiary is expecting 1/3 of the residue of the estate, of course they have the right to know what the house was sold for, what the income tax situation looked like, what the estate lawyer got paid and the estate accountant got paid, because all of those factors affect what that beneficiary receives. So in many ways, an estate administration is a conversation. It's an ongoing conversation between executor and beneficiary. So choose wisely when you're choosing the beneficiaries of the residue of your estate. And hearkening back to the conversation about executor, consider the dynamic between executors and beneficiaries when you're planning out your will. A final point here about bequests to grandchildren. I'm often asked by seniors who have adult children and grandchildren, hey, I want to split my estate equally among my 3 kids, right? They're in their 40s, their 50s. They're still the main beneficiaries of my estate, but I have a whole bunch of grandchildren ranging from maybe 6 months to 20 years old. And I want to give them all $25,000 each. And I did the math. It's not going to eat up a lot of my estate. And I want to give this $25,000 gift to these 10 individuals, ranging from infant to young adults. I often will ask that client, are you sure? Because there are some downsides to doing that. So here are a few to consider. In this scenario I put to you, there are minor grandchildren. There's kids, there's little kids who are not ready yet by law to receive that money, right? And that age, by the way, for everyone's 18. So if we're giving money to minors, we have to set out in the will who's going to hold that money for them and until what age. We're creating something called a trust. It's a relationship where someone holds money for the benefit of another, so to speak. So we're creating work for someone. Again, don't get me wrong, a $25,000 gift for a 3-year-old is a very kind thing. What a great head start on life and education. But we're sticking someone with a minimum 15-year job of having to keep that money safe, keep that money invested, file a tax return every year. And now suddenly that $25,000 gift is becoming a bit of a burden. So do consider if there are minors involved, we have to create these trust relationships. Furthermore, on this idea where perhaps the person writing their will has very young grandchildren, like babies, they might have more grandchildren down the road. So let's play this out. If that person was to pass away and these 10 grandchildren receive these $25,000 gifts, but more grandchildren are born after their death, well, those are grandchildren who will not benefit from these gifts. That individual, the deceased, has inadvertently disinherited their future grandchildren. That might not sit right. So I often ask clients, hey, if you're going to do this, let's do it at a time where you've met all your grandchildren. Ideally, maybe they're all over 18, and you've certainly met them all yet. So your kids are all done having kids. And finally, my final point in this slide, inadvertent imbalance among children. So let's stay on this topic where you have 3 adult children and 10 grandchildren among them. Let's imagine one of those children chose not to have kids of his or her own. You know, he chose the vocation of being married, but they did not have children. He is in a position to potentially say, this estate was not balanced out and distributed equally among the 3 kids, because I didn't have children. I chose not to have children. My siblings between them had 10 kids, and each of their households, through this gift of $25,000 each, my brother and sister's households received a boost of money that my household didn't receive. Granted, I didn't have children, but at the end of the day, the house of my brother, the house of my sister, and my house were not treated equally. Now, again, I see many different arguments on this point, but I see it all the time, where that child who had no children or less children is put off by the fact that there were gifts to grandchildren. Again, there's nothing legal here. There's nothing, it's not a legal issue per se, but it's more of a personal and chemistry matter. And it's something that I like to put to clients when they give gifts to grandchildren. Is there a perceived imbalance? And if it's not going to sit right, then keep it simple. Divide it among your 3 children and leave it there. Let your kid who had the 5 kids send some money down to his kids if he wants to, and treat your 3 kids the same. That's my general starting point. Now, I think I'm running a little bit late here, I think, on some of my slides here. I do want to put a hard stop on at least 10 minutes for questions. So I might pick up the pace here on some big slides. Starting with probate. I'm asked this question all the time. What is probate? Or I might be told, I heard probate takes years, or I heard a story about my friend's grandmother where the estate was in probate for months and months and months and nothing could be done, and then all these probate taxes have to be paid. Well, let me try my best to dispel some of those myths and provide some clarity on what this probate is. So what is probate? In order for an executor, so after someone's passed away, in order for the executor named in the will to administer certain assets in the estate, they have to get this thing from the court called a grant of probate. And here in Alberta, it's from the Court of Queen's Bench. It's not from the provincial court. It's not from the municipal office. It's not from the Harry Hayes building downtown. It's from the Court of Queen's Bench. So what is probate? Probate is essentially confirming that the will is valid and formally appointing the executor as the executor of the estate. Is probate necessary? Absolutely not. Not in all estates. Some estates, we don't need to go through this process of probate. It's dependent on how much money is in the bank accounts owned by the deceased or investments owned by the deceased. It's dependent on whether there is real estate owned solely by the deceased. And there's some other factors. If there's questions about the validity of the will, if there's dependent family members, probate might be a useful tool. More on that later. But I like to, and I think I've done this before in previous presentations, but I like to do a little scene here to sort of paint the picture. Let's pretend this is a will, right? And it appoints me to be the executor of my uncle's estate. So John is the executor of my estate, and my uncle has died. So I take this will. It's a good will. It's been written by a lawyer. It's valid, signed, witnessed, all the whole 9 yards. In this hand, I have a will, and say in this hand, I've got a death certificate. And with these 2 documents, I go to my late uncle's bank. Okay? And I let the bank know that my uncle has died, and I show them these 2 documents. Now, the bank is in a position, based on these documents, frankly, to hand over the money or not. It's that simple, really. There's more to it, but at a high level, what the bank is assessing is whether they're in a position to give their late client's assets to this man that they've never met, who's holding up a will and a death certificate, right? Who presumably has some work to do, right, as an executor. Now, what the bank is doing is assessing risk. Specifically, how much money did the deceased person own, right? And what we find, and this is a number that varies from case to case, bank to bank, situation to situation, but if my uncle, for example, had about maybe a fairly modest amount of money, maybe $25,000 between a checking and savings account, I would wager that that bank, based on these facts, would probably transfer that money to me so that I could administer this relatively modest estate. What they're essentially saying is, hey, the will looks valid. That's a death certificate from a funeral director. And this guy's smile seems legit. He's got ID. Let's give him the money. We don't want to stand in the way of an estate administration. But let's change the facts. Let's say my uncle had $500,000 in cash and investments. the story changes. The bank still might like my smile, and they still like the will and the death certificate, but it's likely an internal policy that they'll say, that's just not enough for us. We want probate. We want that will reviewed by a judge and stamped essentially as a valid will in order for us to hand over that money to you. We want the certainty that a judge has signed off on your authority as executor. That is the heart of what probate is. It is an institution that's holding property, saying that they want more than just a will, they want validation of the court, right? I'll take it further. If my uncle owned real estate, say he owned a home in his name alone, then it's a foregone conclusion. There will be a need for probate there. It's impossible, really, for me, in most cases, to be able to sell my uncle's home without a grant of probate. So what does this look like, practically speaking? Well, I have to apply for probate. So it's something that anybody can do. You don't need a lawyer to apply for probate. You're submitting to the court the original will, and I would say about a centimeter thick worth of application documents detailing family history, assets of the estate, and some other details about the deceased. The court will process this paperwork, and currently in Calgary, and this varies from judicial center to judicial center across the province, but currently in Calgary, Alberta, we're looking at about 4 months for your probate application to be approved. And that's assuming that all your documents are in order and there's no issues with the will, and there's a few other factors, but generally speaking, if your probate application is in order, you'll see it returned to you with that judge's stamp and seal on there. 4 months. So during that 4-month period, that executor, I'll use myself as an example with my uncle, during that 4-year period, those bank accounts are frozen. During that 4-month period, the bank accounts are frozen. During that 4-month period, I'm not able to sell the house. There are exceptions to this, and I don't want to get into the weeds, but generally speaking, this is what we're looking at. Now, yes, we're looking at 4 months for this probate process, but does that stop me from being an executor? Absolutely not, right? I can clear my uncle's house and prepare it for sale. Maybe there are some small bank accounts that I have access to that I can use to pay taxes, work with the estate lawyer, advise the accountant on the tax return. Personal effects. You don't need probate to distribute the personal effects or family photographs. I guess what I'm getting at here is, although probate is happening concurrently during this estate administration, there's a whole host of tasks that an executor can do. So when I hear about this idea that something's tied up in probate and nothing could be done, oftentimes that's not quite true. Probate is happening, but the estate administration as a whole, that 2-year project, is absolutely still happening at the same time. Probate taxes and probate fees. Be mindful here. Here in the province of Alberta, there is a fee associated with applying for probate. And that fee tops out, as of now, at about $525. There's a few extra dollars there depending on how long the will is, but we're looking at about $550, we'll say, to apply for probate. That's a flat fee for an estate worth $250,000 or up. Okay, so an estate that's worth $250,000, the fee is $525. An estate worth $250 billion, the fee is $525. That is the state of the law here in Alberta. But when we look to our neighbors in British Columbia or throughout the country, it is not a fee, it is a tax, all the way up to 1.4, 1.5% of the entire value of the estate. That can be a lot of money. And estate planning, this whole process of preparing your will and structuring your assets, this whole process of estate planning in other provinces often involves this initiative to try to avoid probate so we can avoid that tax. That is not a concern, generally speaking, here in Alberta. So for those who are thinking, oh, I want to avoid probate, so I want to avoid fees, that's not entirely a big concern here in Alberta. There are some other benefits to probate, or some benefits generally to probate I should identify here. Firstly, probate is conversation. Okay, when an executor applies for probate, they're required to serve a whole bunch of documents on a whole host of people. So for example, remember that whole beneficiaries of bequests, the people that receive fixed gifts, $1,000, Coca-Cola bottle collections. In order to apply for probate, the executor has to prove that they have served a notification on that individual that you are getting $1,000. Okay, we've created conversation, notification. For beneficiaries who receive residue of the estate, they get a lot more. They receive a copy of the will, and that centimeter thick worth of documents, the beneficiaries of residue are served with that information. They get to see what this estate is all about and what it's worth. If there are questions about the validity of the will, and this is rare, everyone, but from time to time, there are members of the family or the deceased had friends that say, that will is not real, right? And it might be a contentious issue, and it might be a very active choice of the executor to say, I am going to apply for probate and have a judge take a look at this so that I have the certainty that I'm not walking around with a will that was written late at night, maybe by a neighbor and who falsely signed a name. I know that sounds like stuff that comes out of novels, but it happens from time to time to some degree. And it really is in the discretion of the executor to say, you know what, I don't need probate based on the assets, but I'm going to do it because there's some whispering going on around the family and I want to shut that down. And finally, this is a very sort of granular detail, but if a person passes away with dependent family members, such as adult children who are disabled and unable to earn a livelihood, maybe a person passes away and there is a surviving spouse who did not receive all of the estate. These are individuals who have a claim against the estate. These are individuals that can raise their hand in court after your passing and say, I didn't get enough, or I didn't get anything, and I need something because I'm a dependent. By applying for probate, what you've done, what that executor does, is they've started the clock on a statute of limitations, right? There is a 6-month window post-probate where these individuals identified can make their claim. So an executor might very strategically apply for probate so as to open the door to these claims and then shut the door to these claims, right? As you picked up earlier, I hope you know the role of executor is complicated and it puts them in the hot seat in many, many ways. And probate is actually a very useful tool for the executor to protect that executor and allow them to do their job as effectively as possible. Jointly owned assets. This is a topic that faces a lot of Canadian seniors. And the scenario on the slide here really kind of sums it all up. Let's imagine a senior mom who's widowed owns her home and her checking account in joint names with her adult son. Not uncommon. When we do these presentations with groups, I ask everyone to imaginarily put up their hand. I don't want to embarrass anyone. Very common. People are like, they're nodding, like they'll say, yep, that's me. Well, let's ask ourselves first, why do many seniors do this? Many seniors do this because, maybe using these facts, maybe mom doesn't get around as much anymore, right? She's certainly mentally capable of managing her affairs, but physically she's not up to it as much. Maybe there's some mobility concerns. She can't get to the bank as often, and it makes a lot of sense that her adult son is on her account, so he can do banking for her. Not his money, not his money. It's all mom's money, but he's on there for convenience. Even as a joint owner of the house, it's convenient for him to be able to talk to the city, talk to the utility providers, again, for convenience. Still mom's house. And the expectation in that scenario is that while mom's alive, son has access to these accounts and this property, but upon passing, these assets are considered part of mom's estate. They're not gifts to him. That house is not for him to keep. That bank account is not for him to take upon mom's passing. So be mindful. So a couple of things here, looking at the slide. Now, if we're looking at spouses, so say a husband and wife, for example, who own their house in joint names, very common arrangement, right, with a married couple, and say that the husband passes away. When they own their house in joint names, we use a term, by right of survivorship, the wife owns the whole property, right? The last to die owns the house, so to speak. And that makes a lot of sense for married couples who own their checking accounts together and their houses, their homes together. And that's the way the law, that's what the law states. If we're looking at spouses that have joint accounts, the survivor takes. But if we're dealing with mom and an adult son, if mom passes away, it is presumed that that adult son now holds that house, holds that bank account for the benefit of the estate. He now essentially has to hand over that asset to the executor of the estate and say, okay, mom died with that house in my name, but that was just symbolic. Executor, here it is. You have work to do as the executor. Maybe that son is the executor and this was intentional. Maybe it was planned out. I want the house and the accounts to pass to that son without probate, huh? And now the son will divide the assets in two because he has a sister and the will says divide everything by two. What I described to you is a setup that we see all the time, right? Mom's intent is for the son to now receive these assets and he's going to administer it as part of the estate. Maybe mom has just one son, one adult child, or one child generally speaking, and that's that son. And that arrangement makes a lot of sense. The assets flow to that son without probate because of the joint ownership. And that son, he is the estate. He is the sole beneficiary. So based on those facts, this joint ownership arrangement works great. But let's change the facts here. What if the son was always under the belief that the house was going to be his to keep? And maybe mom even said casually in discussion, oh, that bank account is going to be yours. You don't have to share it with your sister. And then upon mom's passing, all we have are conversations. Well, the son's in a tough spot. He has to prove, normally in writing, through writings from mom, that was mom's intent, because it is presumed that he's going to share that house with his sister. If this resonates with anyone here in our presentation, you got to watch out. I think the takeaway here is make your wishes clear. If you're adding a child, an adult child, as a joint owner of your bank account or a house, make your wishes clear. Make those wishes clear in your will. What is your intent? Is it a gift or does it form part of your estate? Right? Put it in letters. Communicate to your children what you're trying to achieve. Another thing to consider here are some possible risks. So let's say while mom and son are alive and well, and they're owning these accounts and house and joint names, and then that son, that adult child, has some problems with his credit. Maybe he goes through a bankruptcy. Maybe he goes through an acrimonious divorce with his partner. Watch out. That house that's in his name for symbolic and convenience purposes, now we're under the radar of your son's creditors, and certainly on the radar of your son's separating wife's divorce lawyer. Because that lawyer, she's very interested in that house. And why is it in joint names? Maybe the son owns some of that house and should be considered in that divorce settlement. So again, when we add our adult children as joint owners, we're exposing our assets to our children's personal lives. And finally, I don't want to talk too much about tax today. We can probably spend several mornings talking about tax, but there are tax implications here with adding adult children to accounts. We could negatively affect our principal residence exemption, right? Like if your house is jointly owned with you and your son also has a home of his own, are we adding questions here as to, well, whose house is this from a principal residence exception, right? And there's a whole bunch of deemed disposition stuff going on here. Talk to your accountant or lawyer, but be mindful of these issues. I'll say this only very briefly. If this joint asset arrangement suddenly scares the heck out of you, or it might not serve what you want, right? You know, again, going back to our earlier slide, we want to create access. We want to make sure that your son can access our accounts to help with banking. Well, there's one way to do it, and it's a simple one called the power of attorney. The enduring power of attorney is a document that you can create that says, my son has authority to do these things, but you don't give him ownership. He's not a joint account holder. He's not an owner of your home, but he has authority through this document called the power of attorney to bank, for example, on your behalf. Now, I think I'm going to have to rush through these slides, these last two slides, not just for want of time, not for want of importance. And it's the personal directive and beyond. So the quick background, the personal directive is the name for the document here in Alberta, where we appoint an agent to make personal and healthcare decisions for us if we are unable to make those decisions on our own. That's the main role of this document. The other role or purposes of this document are to provide maybe some wishes, which are non-binding by law, but non-binding wishes regarding our care. So maybe your views on heroic measures, your views on quality of life. you're going to use this document to appoint guardians for minor children, for those who have minor children. So if you fell ill, have an 8-year-old, and were frankly unable to parent, your personal directive can be used to choose a sort of a temporary guardian for that 8-year-old. And the personal directive can even make directions regarding organ donation. Some things to consider. Obviously, the choice of agent is huge. So that's kind of harkening back on our conversation about executor. Who are we choosing? Is this someone that shares our values, someone that can be an advocate for our health care? It's a big part of this role. Do consider compensation. This agent is not paid, and the law does not say that they shall be paid unless you say so in your personal directive. So if you want your agent to receive some money for this work, or at a minimum be paid back for out-of-pocket expenses, we should make that clear in our personal directive. And it's also common to consider in your personal directive other people. So for example, you might choose one person to be your agent. That's the wise thing to do. But you might want to say, my agents shall inform my other adult children that the personal directive has taken effect, or they shall consult with them, hear their advice, that they can make a decision on their own. So involving other people is something we have to consider very carefully. And with a minute to spare, I want to identify 3 documents, and there's many more out there, but there's 3 documents specifically here in Alberta that accompany a personal directive: goals of care order, supported decision-making authorization, and trusted contact person. The goals of care order is something that you can fill out with your doctor. I like to see this, and I'm maybe the physicians and healthcare professionals out there will correct me, but I see this as standing orders. This is you saying with your doctor, signing together, this is the level of care that I want to receive. This is the type of interventions I want to receive. I want to express where I stand on ICU, resuscitation, life support, comfort measures. There are 7, I believe, 7 levels of care that you can choose that say to the world, say to your healthcare providers, hey, if I can't make decisions, this is the level of care that I want. And you sign this with your doctor. So I do encourage seniors to consider this and inquire with their family doctors. Supported decision-making authorization, not commonly known or used, I find, but this is a great tool that you can fill out. This is an online form. In fact, I've got one right in front of me over here. It's an online form that you can fill out. Here we go. And it allows you to choose someone to be what's called a supporter. And this supporter has some limited access to your personal medical information. And they also are able to sit in on, for example, meetings with your doctor and help you make decisions. Now, do be mindful. They cannot make decisions on your behalf, okay? They stand alongside you, so to speak. We see this as a very effective tool for seniors who might rely heavily, maybe on one of their adult children to help them make decisions. Maybe their cognition, maybe their state of mind is not as strong as it used to be, and the help and support of an adult child or friend really helps them get through these complicated doctor's visits. I see a lot of clients who, where English is not their first language, and their adult child who is very proficient and fluent in English, they want to they serve as their supported decision maker. So they want to bring that child to meetings with their social worker or their physician. So this supported decision-making authorization is a great tool. Be mindful, it loses its effect if you lose mental capacity. So a person who has this SDM document, if they later lose capacity, this decision-making document ceases to have effect, and then the personal directive takes over. Makes a lot of sense. And finally, this is something that I've just come across just in the last year or so, and it's called a trusted contact person. I'm actually holding up a newsletter from a banking professional, and he's identified this I call it a tool called trusted contact person. This is designed to curb against identity theft, fraud, suspicious activity, elder abuse. What you can do essentially is inform the bank who your trusted contact person or persons are. And if there's any suspicious activity in your account, something that just doesn't look right to the bank, and they know they've got a radar for this, they'll contact your trusted contact person and say, hey, we have you listed here. Your mom Bernice has you listed, and there's some transactions that don't make sense. I think you should talk to mom about this, right? Again, not a lot of authority. This trusted contact person cannot make trades on your account. They cannot withdraw money, but it's someone that acts as a backstop if there's some suspicious activity. So these three documents I see are very helpful to stand alongside a personal directive. So abrupt ending, because I want to try to take some questions. Thank you, everyone. Thank you for putting up with these slides today.
We've got lots of time. We've got lots of time, Jonathan, that we'll make sure that we get to our viewers' questions here. I know you were answering some along the way, but and I would suggest that you take note of Jonathan's contact here. Jonathan, it might be an idea if you don't mind popping your email address or phone into the chat in case anybody wants to capture that. And if you want to enter your screen share, then we'll get to the questions here. I'm not sure. I know you were answering some along the way, but and you know, as part of Advanced Care Planning Month, great information that you shared here today, and I think we've learned so much about the importance of advanced care planning through the presentations that we have done this month. Not only working with a lawyer like yourself to make sure that you have your power of attorney, your will, and your personal directive in place, but we've learned more about, and thank you very much for touching upon, the goals of care, working with your doctor to make sure that you have that laid out so that your loved ones or emergency first responders have that information at hand. So we have the presentation that we did with Alberta Health Services up on our Kerby Centre YouTube channel as well. And we will have yours up imminently, so that if anyone would like to go back and review any of that information, or please reach out to Jonathan, or feel free to contact me and I'll be happy to put you in touch. So we've got some questions in, I'll just go to the chats here quick. I know that you were answering some. Rupa, would you mind to send us goal of care designation order and supported decision-making form? I think you need to, Jonathan, I'm not sure if you can answer this, but I know that when we did our presentation, Alexandra gave directions as to where to go to get the goal of care form. Do you have anything further on that?
None at all. I went on last night and I typed goals of care designation, and I left the first hit was the AHS form, and same for supported decision making. It'll be your first or second hit on a Google search. So it should be quite easy.
Yes, and again, if you go to review the video that we have, Alexander gives directions on how to get those forms, and then take to your doctor and make sure that your level of care is noted. Brian, what is the status of my spouse-free family home owned by me when I die? Does ownership flow to spouse automatically?
Great question. So what we have to do is look at the title. Right? We have to look at how is your ownership registered on the title of your home. So between spouses, it's very common that the ownership is jointly owned. So what you're going to do is you're going to look at that title if you've got it. You're going to see your name, you see your spouse's name as expected, and then here's the magic words: as joint tenants. I'm going to type that in right now. As joint tenants. This is the phrase that should give you, I think, hopefully the peace of mind that if you were to pass away, or if your wife was to pass away, the other owns the house automatically. You don't need a will, and it happens immediately. Okay, not jointly owned. Thank you, Brian. Okay, well, that's made it very clear. Okay, if that's the case, then Brian, if you were to pass away, your one half, or your portion, because it's not always a half, sometimes you own 30%, however you and your wife set it up, your fractional ownership of the house is now controlled by your will. So if your will simply says, I give the residue of my estate to my spouse, or I give my ownership of my house to my spouse, then it will flow to her. But it won't happen overnight. It won't happen as fast as the joint ownership scenario. By it going through your will, going through your estate, so to speak, It'll take time and it'll take some expense. I'll be blunt. Your executor is going to be going through that probate process to get that 30% fractional share over your wife. It's, in my view, it's just paperwork, but I get it. 4 months of waiting, some legal expense certainly doesn't give people comfort, but it is essentially paperwork.
That's a good question there, or information regarding the house. It's made me consider my the will, because I think I've just basically suggested that my children split everything. But should I specifically say that my home goes to them so that then they have the ability to sell it without having any complications?
That's a great question, Colleen. And I'm gonna, on the next presentation with common questions, I want to put that there. I mean, I think the broad question I'm often asked that to carry on there is, do I need to name my house? Do I need to name my bank account?
Mm-hmm.
And the short answer in most cases is no. You don't have to do that. Like we'll single out Colleen. If Colleen's wish is for her assets, all her stuff is to be dedicated to her children, there's no need to single out the house. Right? The executor has control over the house by way of the will. And, the executor will go ahead and sell it anyway and then split the proceeds by 3. But if Colleen's wish was, oh, well, I have a daughter and she very much wants the house and she'll buy it fair and square from the estate, now we're talking. The will should say she receives the house and the other 2 receive money or something like that.
That's good to know. That's good to know. Thank you. And Neil has said, excellent presentation by an excellent speaker. Thank you. And come on, move up there. Yes, and with the recording will be on our YouTube channel, Sam. And JP, if someone has a young adult beneficiary who has been recently diagnosed with a mental illness and is an addict, can their will stipulate how that beneficiary can or cannot use the monetary gift he or she inherits? Or is it best to simply not name them as beneficiary? That's a tough one.
Oh, yeah. And JP's right on both fronts, right? Those are all possible options. And I've been involved with all of these coming together. So let's start with keeping the young adult beneficiary in your will, but creating terms, right? Creating a trust. So it's this idea where someone is going to hold the money for the benefit of this person who's struggling. And we would set out a very particular type of trust that protects that person and protects that person from that wealth in many ways. So just as an example, we might say maybe there's a stipend of money that's paid so that the money is controlled. The wealth is controlled as to how it's used. Sometimes we say there is no stipend paid out of that trust. Sometimes we say the trustee shall give money to that young adult only as the trustee sees fit. That young adult has to prove that they have a need. Otherwise, it's locked. And sometimes we have to do that for someone who has addiction challenges, spendthrifts, or beneficiaries who are disabled and perhaps receiving AISH, that's the disability support here in Alberta. We craft trusts that are actually highly protective, and not a penny leaves that trust unless the trustee says so. Sometimes we have to do this. So again, I can talk about this stuff all day. I love helping with these types of estates, but I guess the takeaway is, yes, it's possible to create terms, trust terms, to control how that gift is given to that beneficiary. It is possible to not name them at all. That is true. Now, we have to be very careful. Now, if that person is a child of the deceased, right, your adult child, might not be wise to do that. I'll get there in a second. But let's imagine if it's a person that's not related to you, maybe it's best to give it to somebody else with an understanding that they're going to help out this nephew. There's a whole can of worms here talking about dependent adult children. But I guess the takeaway is dependent adult children have a right to make a claim against our estate. They can raise their hand and say, I need more than what I received, right? So even if, at any age, 18 and above, as long as they're unable to earn a livelihood due to a mental or physical disability, they have this priority, so to speak. And I would be very careful about excluding that child. I would keep them in, but be very careful about the trust planning.
Mhm. I want to get to some of the Q&As here as well. A couple more questions here in chat. Erica said her brother was executor. He gave gifts to his kids of 30,000 each, then did the sibling division. So I lost 25,000. Do I have recourse or just let it go?
Okay. Now I'm trying to, is this in the Q&A?
No, that's in chat.
Okay, yeah, pardon me. I just wanted to see if I could cross-reference that one more time. You know, it's it's a very specific question. I know it's you'll roll your eyes at this, but I would talk to a lawyer about this, right? So my brother is, okay, I'm looking at it one more time. I don't want to leave you high and dry here, Erica. Let me give this a shot here. You can. So I lost 3,000. There's always recourse, I suppose, but it's often more trouble than it's worth.
Yeah. Do you want to go there?
Do you want to go there? Yeah, and talk to a lawyer.
A couple more here quick. Catherine, people can complete and use transfer on death forms to transfer assets directly on one's death. If one does this for most of the assets, does this reduce the cost and time involved for the executor? Is it better than using a trust?
Yeah, it's possible. You know, the idea is you hand out your stuff before you die. That's the spirit, I think, of what this person is trying to say. Not quite, but in a way it is. Because if you're creating joint ownership, if you're giving assets to other people, I presume there's an understanding that those assets remain available to you during your life, so you can live, right? Mm-hmm. So I guess the participants can see the frustration here. If you're shipping out your stuff before you pass away on a bunch of handshake deals, you can get in some trouble. And I don't want it to make it sound so informal and crass, but that's effectively the issue we see here. A state administration is not as awful as it sounds. And in many ways, a state administration gives you certainty that you are owning your assets till your death. And a state administration also makes it clear that your executor is going to be follow wishes according to a will, as opposed to a network of handshake deals.
I'd like to get to some of them because we've got quite a few in Q&A here. I'd like to get to some of those. If you have answered them, then please feel free to let me know. Hank has asked, in the event of a conflict between an agent of the personal directive and the EPOA or POA, which decision prevails?
Okay. On the face of it, nothing. Neither, right? You know, what you're looking at here is, under the power of attorney, someone that's managing your assets, your money, your investments, your land, anything that has to do with that can be turned into money, this person's in charge of. Over here under the personal directive, the agent is in charge of your healthcare needs, your housing, medicine, treatment. In theory, these two worlds should not collide. They should not collide, but they can. And great question. For example, this person here can say, I want dad to receive the best care possible, and I've identified a physician in Fiji who will perform a procedure for my dad that'll help him live for 5 more years. Well, in theory, this person can make that decision, but they cannot pay for it. This person's in charge of funding it. And if they don't agree, this is the issue, right? We often look at the documents. The personal directive document and the enduring power of attorney document might have a tiebreaker clause. And it's not uncommon to say that this person wins. For day-to-day issues, that can be effective. But I want everyone to be mindful. As they look at their documents, they'll see this tiebreaker clause and feel like they've got the next best thing since sliced bread. It is not true. And in that silly scenario that I put forward, if this person here is saying, I want my dad to get experimental surgery in Fiji at a cost of $350,000, this person, even with the tiebreaker clause, might say, that's unacceptable. Dad has $400,000 in risk savings, and that's it. And if we're going to erode his wealth based on this whim that you looked up on the internet, he's going to be in a lot of financial trouble. So even in a tiebreaker clause situation, unreasonable decisions can still put everyone at odds with each other. This is a complete non-answer to your question, but I hope it does provide some insight into some of the concerns and how complicated the answer really is.
Thank you. Maureen has asked regarding planning a funeral, is it a good idea for funeral arrangements to be put in a will? I'm thinking that the executor and family may have difficulty agreeing on the details of the funeral. Thanks, Maureen.
I love it. As much information as possible for funeral arrangements is better. You know, if you're in a good position to make arrangements and maybe even pay for them, I'm not going to go into whether that's a good idea or not. I know that's a whole other issue that funeral directors can tell you all about. Making arrangements generally, again, through the funeral home, through your will, gives clarity. The executor is in such a tough spot, right? You hear this all the time. It's like planning a wedding in a week. And the decisions they have to make are not going to please everyone in the room. And if you've given your executor a tight list of things that are important to you, then that's a whole host of decisions that poor executor does not have to make. So yes, use your will. And hey, if it's not in your will, then you don't have to call up your lawyer and say, I need to reopen my will because I have a view on cremation. You can keep this in a memorandum, like a written note, right? It doesn't cost anything. Put it on a Post-it note, keep it with your will. Sign it, date it, no problem.
Just where someone could see what your wishes are. And Maureen has also asked if my daughters are listed as beneficiaries on a TSFA, is the TSFA considered part of the bequest?
No, I think another way to answer that question is those daughters get that TFSA outside of your will, full stop. That's normally how it works, right? So if your daughters are named as beneficiaries of the TFSA, upon your death, they can go to that bank with a death certificate. And, you know, over the course of filling out some paperwork, they will get half that account each. It's that simple. If the bank asks for a will, they can actually say, this is not even the business of the estate. This is a relationship between the bank and the named beneficiaries. I fight with banks on this one a little bit, and I know there's different views, but from my perspective, it's that simple. So it's, by definition, it's not a bequest in the will because it's not part of your estate, it's not a part of the will.
There you go. Anonymous has asked, can the benefactor be executor too? And what is the best way while alive to give a gift in a monetary gift to a son or daughter to stay in the blood families?
So I'll answer the easier question first. Can a beneficiary be executor? Absolutely. Right? It's not uncommon to say, I have 3 kids. I split my estate 3 ways. So they're my 3 beneficiaries. And my daughter who lives in town, who's among those 3, shall be my executor. Yes, it seems like a bit of a conflict of interest. She's giving and taking both at the same time, but a very common thing to do. She would be mindful though, right? She has to be fair. Even though she's receiving a third, that's something we should always explore, right? If we're appointing our daughter or someone who's going to be both executor and beneficiary, let's explore, even just briefly, what that conflict of interest could look like. So the tougher question though that you asked was, oh, pardon me, where are we? Oh, I lost.
Oh, sorry, I just deleted them. I'm sorry.
Oh, that's okay. They're in the answered section. Yeah, best way to give money while alive. Okay, well, to keep it in the family. So. A few things. I know you didn't ask this question, but I'll put this forward. Do consider giving equal gifts to all your kids all at the same time, even if it's a gift to only one of them who needs it. If you're privileged and in a good spot to be able to give that same cash gift to all your kids, do that. Keep them all even at all times. And I don't think I have to tell everyone why that's good advice. Next, paper it. And finally, paper it. So a good way to do it, to keep it in blood, I think this person is probably asking about exes and maybe spouses, sons and daughters-in-law. Okay, I could have that wrong. I'm sorry if I do, but that's a common concern. There's something called a gift letter or deed of gift. You can look these up on the internet. I do suggest, work with a professional on this, but it's not rocket science here. You're essentially signing a document saying, I, on this day, give to my son, Michael, $25,000, and he accepts it as a gift. You sign it, he signs it. And that is a very helpful tool to make sure that gift to Michael is not a loan that has to be paid back. And furthermore, should Michael go through a separation, he's able to show that he received a family gift. And not to get into the issues of divorce, but family gifts are generally protected from the division of property when there's a separation. So he might be able to, that gift letter, that deed of gift, is a tool to try to keep that $25,000 in his pocket.
Something to document it. Lenore has asked, if my executors are also beneficiary of a certain percentage I assigned to them, are they still entitled to compensation?
Yes, that's a big yes. They're able to receive as beneficiaries, and they're also able to receive for the work that they do.
And she's thinking about asking a lawyer friend to be executor. How much is he entitled to for compensation?
Great question. Okay, the starting point is he's the same like everyone else, right? It sits between that 1 to 5%. But run it by your lawyer friend, because it's not uncommon that the lawyer friend might say, you know, thank you for asking me, I will accept doing it. But he may say, I want it stated in the will that I get to be paid my hourly rate. I get to be paid as I'm a lawyer, right? And that's very common. He is not being selfish. He's trying to do the best job for you. He's trying to say, I'm going to give this all I've got, but I'm going to be setting aside work. So I humbly ask to be paid what my hourly rate is. And I don't want to scare our participants today, but it is measured in the hundreds normally, hundreds of dollars an hour. But run it by your friend and see where he stands.
Do some comparison maybe. Erica, I think we answered your questions that you had in Q&A and chat. I would highly recommend for anybody, if we've missed your questions or if you still want to answers more in depth, that by all means reach out to Jonathan for further detail. Surface Pro, I'm engaged, but what happens if I'm not married and my partner dies? The home is in his name and he has 3 adult kids.
Woo, okay, wow. All right, engaged. I'm looking at it again. I got it.
Sorry.
Oh, no problem, no problem. I could see it. I could see it here in the answer section. So engaged, but what happens if I get married and my partner dies? Our home is only in his name and he has adult kids. So this is a blended family, right? This is a blended family. So the home, so as a common law partner, right? As a common law partner, Surface Pro, you have rights. You do have rights, many. The first one being, I want to make sure I get this right. I believe it's 3 months, 3 or 6 months. I believe it's 3. Feel free to contact me and I'll check the rule on it. But you do have an entitlement to live at the home. Unfortunately, it's measured in months. It's probably not going to give you a lot of comfort, but you do have entitlement to stay at the home. But it gets better. You are a dependent on your spouse, your partner. You have the right to say, I did not get enough. If his will, and I really hope his will does not say I give everything to my 3 adult children, but let's say it does. And let's just, for the sake of conversation, let's say you two have been together for 20 years. If he was to write a will that says I give everything to my adult children, all in the face of his 20-year partner, he's getting a lawsuit cooked up, ready to go. You have the right to raise your hand after his death and say, that's not fair. And based on those facts, you're going to be in a good place to be able to get something out of that estate. I don't wish that for anybody, and it's not a comfortable thing to do, and it's not easy to do, but he would be mindful, as should you, to very carefully plan out your wills to make sure that everyone is okay, for lack of a better term. He might say, and I kind of want to step into his shoes for a moment. He might say in his heart, I am with this partner. I've been with them for 3, 10, 20 years, and I want them to have a long retirement with some of my assets. But I also have these 3 adult children that I always know. I've known them since their birth, before I met her, and I want to make sure they get something. This gentleman is in a struggle, and his will writing can be very complicated, but it's not impossible. A properly crafted will could satisfy both sides, but he would be mindful to work with a professional on that one.
Great. And further question there was, if you're willed an item and it's been valued, then the item goes missing before it goes to beneficiary. Does the estate have to compensate the beneficiary?
Maybe. Depends on when it went missing. If it went missing after the death, while the executor was in control of things, then it's possible that the executor might be in the hot seat. Where did it go? Right? Mm-hmm. It was there, now it's gone. Only you had the keys to the house. So that's a bit of a concern. It may have been stolen, and it's a very innocent, sad situation, but the executor did the best they can. But certainly there's concerns if it went missing after the death. But if it went missing before the death, or in other words, maybe the deceased, frankly, did not own the item at the time of his or her death, what we have is called a deemed gift or a failed gift. Basically, the executor can take the position that the deceased did not own the item at the time of death, therefore there is no gift to give.
And it better not show up afterward.
Oh boy, yeah, and this happens all the time. So careful. Not uncommon that executors are changing the locks before the funeral.
Lenore has said thank you very much, and Brenda has said has offered here that family disputes can be resolved through mediation if the parties involved cannot resolve the wishes of the deceased. So thank you very much. And we've got several more in chat, but I think we're kind of running out of time here today.